Harold David Monaco, Judge. So I offer to say this is for this court during your attention and you shall be heard. God save the United States of America, Florida, and this honorable court.
Morning and welcome to a session of the 5th District Court of Appeals. As Marshal Bordeaux has indicated, my name is David Monaco. To my right is Judge Bob Ployce. To my left is Judge George B. Turner from Brevard County. Occasionally we invite outstanding trial judges to sit with us, and we have the honor of having Judge Turner sit with us today. It has been said that trial judges have to be twice as smart and work twice as hard as appellate judges. But of course, that's never proven to be a terribly difficult task anyway. So, all right, these are all civil cases. Each side will receive 20 minutes. Appellants, if you want me to help you in your reservation of time for rebuttal, let me know, and I'll put it on the clock so that you can see when your time elapses toward that period. Other than that, let's go ahead and get started with LANDQUEST Inc. versus DINES, Das, Jacob Green, and Mr. Tang.
May it please the court, good morning. I'm Joe Williams, representing the appellant in this appeal, LANDQUEST Inc., and I would like to reserve 3 minutes for rebuttal, please. This appeal presents two issues to the court. The first is a question of first impression involving the application of the provisions of Section 55.03 sub 2 of the Florida statutes dealing with whether or not that statute applies to an executory judgment that talks about amounts of money that may or may not be paid at some indeterminate time in the future. The second issue involves a serious deprival of due process of law from the plaintiff in the manner in which the defense's motion for sanctions below was handled by the court and addressed by the court. As to the interest question and the 55.032 question, how that statute applies. This is the fifth appearance of this case before this court, and I think we're 10 years and 1 month into the case now. And I earnestly hope that this will be my last appearance before this court.
I hope so. We're going to have to start a 12-step program to get you guys out.
But basically the facts that we are dealing with now is that a piece of property worth $40 million was sold, and the plaintiff was a real estate broker who had a letter agreement with the seller that if the property was sold, that he would get a 5% commission on the property on the sale, but only when the principal amount was paid. The only principal amount that had been paid at the time of trial was a down payment of $6 million, and that entitled the broker to a $300,000 commission, 5% of that figure. That figure was embodied in the third amended final judgment entered by the trial judge, indicating that that should be paid and that interest should accrue on that from that date. And
on the first payment, on the down payment.
On the down payment. And the judgment contained the words, the magic words for which lead execution issued. Now, interestingly, that judgment didn't contain the 55.032 language, but the law firm who was handling the disbursement of the funds after this court's last opinion in autumn of last year went ahead and paid interest on the $300,000 anyway. So that's behind us. What we are left with now is that when the third amended final judgment was entered, There was no evidence in the record, and in fact, the defense had frustrated our attempts to take discovery in aid of execution to find out when the payments had been made, what dates they had been made, and what payments had been made on what dates, so we could get a final judgment entered that would comply with what they're complaining about didn't happen now. So basically, it was an executory judgment.
Well, wait, no. So there was the full amount of the commission was paid, and you were attempting then to get discovery on when it was paid?
Yes. So we could compute the interest that would be due.
Why wouldn't you have asked the trial court at the time that the judgment was entered simply to include interest language to the effect that you would get your statutory interest when it was paid?
Well, you can only get statutory interest on a vested right and on a liquidated sum. And this, like I say...
Well, there's no question that that's when you have to get it.
Right.
But I'm talking about why the judgment wouldn't simply have authorized that.
Because the right to the interest had not vested at the time.
I don't see how that makes a bit of difference. Who cares whether it had vested or not? If you're entitled to statutory interest, you were entitled to statutory interest, and why wouldn't the judge just put it in there?
Well, I'd given authority to the court that says that unless you have a vested right, you're not entitled to interest.
That's the difference between entitlement and a preparation of the document to account for it when it is paid, when you are entitled to it.
But the point I'm trying to make, Judge, is that when the third amended final judgment was entered, there was no guarantee at all that the money would be paid, because the contract said if the seller had walked away, the buyer had walked away from the deal and didn't pay the money, then we would not have been, or my client wouldn't have been entitled to anything. So there was nothing in the record at the time the third amended final judgment was entered that would have given my client any right to any interest at that time, because of the fact that the way the contract between the parties was structured, that he only got paid if the principal was paid. And if the principal wasn't paid, he didn't get paid his commission. And
I think we all understand that.
And we tried to do the discovery to find out if that had happened, and if so, when, and we were frustrated in doing that by the defense. The first time was at the time of the third amended final judgment, and after the court entered its order, they took an immediate appeal, which frustrated the attempt. And I've tried this again, and after that was short-circuited by the motion for sanctions that I'm going to talk about a little later on this. But there was nothing in existence. There was no evidence before the court at the time this judgment, the third amended final judgment, was entered, on which the trial judge could have ordered interest to be paid. And like I say, because it was executory and because of the way the contract was structured, it might never have happened. It did, but it might never have. And I think you're requiring the judge to be the Johnny Carson character Karnak on the old Tonight Show. I mean, you're requiring him to divine what's going to happen in the future.
Well, I'm not really. I mean, the concluding paragraph, the concluding line in the next to the last paragraph of the third amended final judgment says, if any further principal payments are made to the defendant, then LANDQUEST will be entitled to 5% of that amount to be paid by the defendants under that certain agreement. I don't see why he could not have said, plus interest from the date of payment. Well, I don't understand why he could not have gone further if that's what he intended.
Well, the third...
Because he did include interest in the previous sentence for the stuff already paid.
But that was the liquidated sum in the previous sentence, and I think the operative word in the sentence you read is if. Again, it's up in the air whether or not anything would be paid anywhere down the line. But the court did reserve jurisdiction to award cost, attorney's fees, and other matters associated with that, which I think would cover the question of interest when there was evidence that the principal amounts had been paid. That would give rise then to the commission, but not before that. Okay.
Well, let me ask you this question.
Yes, sir.
Is it necessary at all for a judgment to include statutory interest in it in order for the recipient to be entitled to statutory interest?
I think it is, yes. If there is a liquidated sum that statutory interest can act on. But if it's not a liquidated sum, if it's something that may happen or may not happen, and who knows when it's going to happen, I don't think that a judgment needs to contain that 55.03(2) language, because I think that because that language deals with property rights, and I've discussed this in my brief, that it has to be strictly construed, and I've cited this court some of its cases saying that if a property right is involved, you've got to have strict construction. I'm familiar with the court's holding in Keeney, which was the only case I could find which dealt peripherally with this question. But there you held that the interest rate could fluctuate from year to year to year, and then the year after you held that, the legislature came back and put in Section 3 and said you have the same interest rate all the way through. But if you employ strict construction, which I think you have to, because this is a property right we're talking about, then you've got to put the precise interest rate on the face of the judgment. That's what subsection 3 says. And I think that's clear and unambiguous as can be.
Counsel, you said at the very beginning this is a case of first impressions. To me, that means that you don't have any law to support it. You're just suggesting that this is what the law ought to be?
That's correct, Your Honor. There is no case in this state that exactly concerns this point. And I think that may be, the fact there isn't may be some indication that maybe most judges wouldn't try to put an interest rate on something that may or may not be paid in the future at some time. The judge didn't know when it was going to be paid. I don't see how a judge looking at 55.03(2) could, and then looking at something that may or may not be paid in the future, can say, well, what interest rate do I put here? How do I comply with this statute to put a specific interest rate?
I sat for 5 years as a trial judge, and what I usually said was at the statutory interest.
Well,
whatever that happened to be.
With respect to Judge, the statute has been amended, I think, since you were on the bench, on the trial bench.
I don't think so.
Most recently,
1988 was the most. No, there's a 2003 modification.
Counsel, wasn't that amendment though so that the sheriff wouldn't have to compute the interest and would have a statute that the sheriff could rely on in determining the amount of money that was involved?
I think that's true, Your Honor. I think that's the primary reason for the amendment, but the fact that that was the reason does not take away the mandatory nature of the statute as far as what the judge's duty is in entering the final judgment. And in Orange County, when you have a final judgment, the local rules require you to bring a detailed calculation as to what the interest is and how it was arrived at, and and that type of thing. And
so your position is basically that the judgment must state that you are entitled to interest at a particular rate, or you don't get it.
that's correct.
What if the statutory rate changed and later on the payment was made and you're entitled to interest from the date it's made, and the interest rate has changed from what how would you deal with that?
That's why, in this case, I think you have to have a fourth amended final judgment entered to make the fact finding to determine when the amounts were paid and how much was paid, so that the court can insert the exact and correct interest rate in the final judgment.
So what error do you think was committed below? What error was committed below?
With reference to this particular thing, I think the judge erred in, this goes to the due process question too, and I see I'm getting down on my time, but this all came about with a motion for sanctions filed saying that we were apparently seeking pre- and post-judgment interest. And the motion was filed and went up to the court. It was heard by the court. There were changes in position on the part of the defense. So every time they would make a position and I would knock it down, they would change their position. And the judge entered an order that was in response to the motion for sanctions, the judge entered an order saying the plaintiff appears to be seeking interest on the $1,700,000 payment reflected in the third amended final judgment. The plaintiff appears to be. 57-105 requires an evidentiary hearing by the court to determine whether there is a preponderance of the evidence that the person who's being complained against did anything wrong that deserves sanctions. And the order itself doesn't make that finding and is still talking about what appeared to be happening and use that as a basis for crafting a sanction that was not asked for, and that sanction was that the plaintiff had to write or sign a satisfaction of judgment, and that was the way the trial judge handled that, and that was non-responsive to the motion that the trial judge was acting on. And I could go on about this for a long time, but the nub is that the way in which this was the motion for sanctions was handled from beginning to end denied due process of law to the plaintiff on numerous occasions in numerous ways. And I earnestly suggest to you that the reading that I'm suggesting of 5503(2) should be mandatory, that it has to require the rate to be filed, the rate to be put in the final judgment. But at very least, this needs to go back to the court on the deprival of due process of law, so we can be allowed an affirmative opportunity to respond to what is being said about this.
Thank you, Counsel.
Thank you.
May it please the court. My name is Steve Falger, and I represent the appellees. Before I begin, I wanted to answer any questions any of the judges had.
Yeah, tell me what your position is on whether or not the recipient of a judgment is entitled to interest regardless of post-judgment interest, regardless of whether the judgment itself specifies that.
Your Honor, our position is clear. It is raise it or waive it. Your Honor, if you look, you pointed out that this was something that was dealt with in drafting. could have simply added plus interest at the statutory interest rate from that date forward. That's all that was needed. Case law is full of rights that are clear but can be waived. My brief is specifically pointed out, McGurn versus Scott says anything not dealt with in the judgment is waived. I mean, that's Supreme Court precedent. I don't see this as a case of first impression, even though that wasn't narrowly tied to post-judgment interest. But more specifically, the first, the fourth, and the second DCA have dealt with interest and Chapter 55, and the Supreme Court, I believe in the Argonaut case, said pre-judgment interest, if you could liquidate it, was a matter of right. Despite that, we've got several courts, 2 appellate courts, saying in Emerald Coast and the Home Insurance Company from the first and fourth, saying even if you reserve jurisdiction as to pre-judgment interest, the failure to seek rehearing and get that decided before it goes up on an appeal means it's waived. Your Honor, this requires a bright line test. You either put it in the judgment or ensure it gets in the judgment or it's waived. Otherwise, we're going to have the multiplicity of proceedings that's complained of here today. I've only been involved in 2 of these appeals, but this appeal is wholly unnecessary. As far as the due process argument, if the record will reflect that we had for many months been arguing about whether any further interest payments were due. We had sent a motion for sanctions in October 2006 and revised it again. Initially, the motion for sanctions addressed they were seeking attorney's fees as well under an invalid proposal for settlement. So it got narrowed and narrowed.
Counsel, why do you call it a motion for sanctions? The only sanction that you're really seeking in your motion was attorney's fees, wasn't it?
Your Honor, our motion had, I guess you call it, addendum clause, which said seeks this relief and such other and further release as the court deems just and proper. It's quite clear that we had been in discussions, if you look at the partial satisfaction of judgment, amended satisfaction of judgment, and the stipulation regarding the discharge of the bond, that we are arguing that there was no further interest owed. The interest that was reflected in the judgment had been paid, and they were on notice for a long time that we were trying to get that resolved. In the meantime, the trial court teed up with the status conference the whole issue of the case, and that's when we made it clear that, Judge, we want to add this motion for sanctions. Now, we could have done it just by saying motion for satisfaction of judgment. We didn't have to...
Motion to clarify the judgment. You know, this whole case, what's disturbed to me more than anything else is the rhetoric that went on in this case between counsel in your briefs, the way you, both of you, attacked opposing counsel, attacked the judges, and I just, it was very upsetting to me as I read through the briefs to see that level of emotion in this case. It just was appalling to me.
I apologize for my part in that, Your Honor. I certainly never intended to personally attack counsel or any judge. What we did want to point out...
But it wasn't just you. I'm not picking on you alone. I think it was a little of both.
What we did want to point out is that there were more than one hearing, Your Honor, and there is no question. The weakest argument that's there is a due process argument. There's a pending motion that deals with the satisfaction of judgment, and then the judge enters a status conference, says go ahead and brief those issues. He files a 9-page response with an appendix, very detailed. The court enters an order on that, so there's notice and an opportunity to be heard. And then there's a subsequent hearing, which was March 9, 2007. We filed a motion to supplement the record to give the notice of hearing on that. That was a notice of hearing given over a month before that hearing. There's no transcript of that hearing, so you can't see the additional notice and opportunity to be heard. And I've cited the cases that say, you know, if there's no transcript, you're hard-pressed to say there's a denial of due process. I think this court has a case that says if it's worth appealing, it's worth having a transcript. So the due process argument is the weakest. There's a third argument, though, besides the fundamental right of anything. A jury trial is a fundamental right. If you don't get it in there, if you don't preserve it, it's waived. But there's also a jurisdictional argument, Your Honor, or Your Honors. The jurisdictional argument. This is a a final judgment that's subject of, the second amended final judgment was subject to an appeal, was defended by the appellant, and then the third amended final judgment, which tweaked the second for so-called clerical errors, was defended on appeal. And that was affirmed. And then we're back again saying, well, we want to tweak that judgment one more time. And I think it's a 2005 third amended final judgment. Here we are in 2008. And if you don't draft a bright line rule and don't give the court permission below to enter a satisfaction of judgment, other litigants are going to be hard pressed to figure out what they owe, whether you have to preserve things. The courts are going more and more to, you better preserve it, whether it's your attorney's fees. Now we have 30 days under 1.525, and this is not form over substance. It's given everyone an opportunity to look at this. So I could go over those cases. They've been cited in our brief at length, and the important thing is, even though it's reserved in the final judgment, those other cases from the first and the fourth say, even though you reserve prejudgment interest, it's been waived. The Tamalo case out of the second also says you've got the lien requirement in Chapter 55 that says if you want a lien, you better put an address in there. And in that case, they didn't put the address, and it was clear that they didn't preserve a lien. And this isn't a statute. There are statutes that we have in Florida that say you can't waive a right. I think of the Retail Sales Finance Act, Chapter 520. As a consumer protection attorney, I know there are certain provisions that can't be waived. Section 55032 doesn't say that. It specifically says that interest rate has to be on the face of the judgment. That's the most important thing. And when we talk about interest rate, it's sort of odd that the Supreme Court's wrong because they use statutory interest. They don't say interest at 11% or 9%.
Counsel, what's your take on this case, the supplemental authority that was filed by Mr. Williams here, this Vitt versus Rodriguez case?
You said Vitt with a B, Your Honor?
B with a Vitt, yeah, I-T-T, B-I-T-T.
I don't have that.
Did you get appellant's notice of supplemental authority with that case?
I certainly within the last week I was out of the office. If it was before the...
It was served on the 13th of June.
It's quite possible I did, Your Honor, but I certainly don't recall it. It comes as a surprise to me, but I can't say that I overlooked it either. Your Honor,
There was an opinion by Judge Monaco, by the way.
Brilliant opinion.
I don't want to alarm you, but it was.
So we've dealt with the fact that there's a lack of a transcript. We know that there's at least 2 hearings. We know that there was plenty of time to brief. You've seen the briefing that's gone back and forth. We know we've got a third amended final judgment that has interest when it wanted to. And we think it was a strategy call. You know, there's a lot of fighting over this commission, whether it was earned. And when Judge Hauser eventually changed his mind with the second amended final judgment, I think the appellant was like, we don't want to mess with this right now because he could change his mind again. And for that strategy decision, they may have waived post-judgment interest. But it shouldn't be something that comes back upon the appellees in this case. The policy of finality, the policy of certainty, and the policy of efficiency are all served if this court determines that a bright line rule is best and remands to the trial court to say it's appropriate to enter a full satisfaction of judgment. The trial court this time is reluctant, despite the case Randolph v. Randolph, to do anything, and so is this litigant, because we wouldn't want to seem to be overstepping our bounds. Thank you for your time.
I would like to answer and hopefully allay your concerns about the discussion of the judges and the case. I didn't do that maliciously, and I certainly tried to bend over backwards to indicate that in my brief. I have been trained for the last 35 years to try to figure out what people's motives are when they take a particular action. That's important to me in making a living. And what happened to me in this case is totally outside of my experience of 34 years of practicing law in this state. It has never happened to me before in this fashion. And when I'm confronted with that, I'm trying to figure out, well, I mean, I know the trial judge, and I know that he doesn't usually do things like that. And so I'm trying to figure out what could have motivated him to do what he did. And what I came up with was he was the administrative judge. He had maybe...
But my point is, what has that got to do with the issues in the case? Argue the issues in the case. Don't try to figure out what motivates a judge. Just argue that if it's either right or wrong. If it's an error, then bring it up to this court and we'll deal with it.
Well, like I say, that was something I've been trained to do, and I was trying to without attacking the judge, indicate what my insight was. And if that offended you, I apologize for that. But it was not intended maliciously. I will assure you of that.
Let me just cite to you what one of our law clerks, in analyzing this case, said. Both parties attempt to dilute the real issues in this case in a sea of verbosity, overflowing with histrionic slights directed towards trial counsel as well as the trial judges. And frankly, I agree with that. I think it was, and I was.
And Judge, in response to that, I would say that, as I noted, this case has been going on for 10 years. And
is there another case in the Ninth Circuit that's going on that long?
Not since I've been there, I don't think.
Okay.
But it has been a hotly fought case, and if that was the interpretation of my brief, it certainly wasn't intended that way. My time is up.
Counsel, your time is up.
Thank you.